Okay. May I ask who the Chief Justice for this round is?
That would be the one who was talking just now, so that's me.
You? All right, thank you, Chief Justice.
Before I begin my submissions, can I just ask if everyone can hear me all right and if everything is all right on my end? All right, I will then begin my submissions as well as my timer. Good morning, members of the court. My name is Shania Herjai. My co-counsel is Sydney Gummerson, and we are counsel on behalf of the appellant, Her Majesty the Queen. It is the position of the appellant that the Supreme Court of Canada incorrectly ruled on this matter, and as such, we are respectfully requesting that the members of the court today allow the appeal and enter a guilty verdict on both counts of hunting without a license and hunting big game while not being a resident of Canada under Section 11(1) and 47A of the Wildlife Act, respectively. This case should therefore be remitted to the trial court for sentencing. The appellant has three submissions that will be addressed today. First, I will submit that the constitutional protection of Aboriginal rights under Section 35(1) of the Constitution Act 1982 do not extend to an Aboriginal group located outside of Canada. A purposive analysis of the relevant linguistic, philosophic, and historical contexts shows this in regards to Section 35(1). Second, my co-counsel will submit that even if Section 35(1) were to extend across the border, Mr. Desautel cannot prove that he was exercising an Aboriginal right to hunt in traditional territory, as the Lakes tribe lacks continuity with the pre-contact Sinix group practices. In our third and final submission, my co-counsel will then submit that there are potential consequences stemming from ruling in favor of the respondent. Before I proceed, would the members of the court like a brief recitation of the facts of the case?
No, counsel, you may proceed.
Thank you, Justice. To begin, the Aboriginal rights recognized and affirmed by Section 35(1) are best understood as, first, the means by which the Constitution recognizes the fact that prior to the arrival of Europeans in North America, the land was already occupied by distinctive Aboriginal societies. And as second, the means by which that prior occupation is reconciled with the assertion of Crown sovereignty over Canadian territory. Moving forward, it is clear from the text of Section 35(1) that to fall within its scope of protection, an Aboriginal group must be an Aboriginal peoples of Canada. The question then raised by this appeal is whether a group whose members are neither Canadian citizens nor Canadian residents can meet this condition. And it is therefore the position of the appellant that Mr. Desautel, as a non-resident of Canada, non-citizen of Canada, does not fit the description of Aboriginal peoples of Canada as defined in the Constitution Act of 1982. However,
for a quick moment, Indians, as defined in the Indian Act, weren't citizens of Canada until 1965. Does that mean that they wouldn't have Aboriginal rights in Canada?
Yes, Justice. It is the submission of the appellant that going by the definition of an Aboriginal peoples of Canada in the Constitution Act of 1982, rather than any other legislature, groups located outside of Canada do not fit the description of Aboriginal peoples of Canada. However, the appellant wishes to acknowledge the importance of reconciliation and Aboriginal perspectives, which involve a strong connection to ancestral territory. It is crucial to be sensitive of the Aboriginal perspective itself on the meaning of the rights at stake. The purpose of ensuring Aboriginal rights to be protected under Section 35(1) is to recognize prior occupation and promote further reconciliation. Jurisprudence has characterized reconciliation in terms of the relationship between non-Aboriginal Canadians and Aboriginal peoples as full and equal members of and participants in Canadian society.
Counsel, you talk about the Aboriginal perspective, but is the Aboriginal perspective in this case not directly contrary to the Crown's perspective?
Justice, can you elaborate or rephrase that question?
Well, I mean, the Aboriginal perspective in here, in part at least, is that given the ancestral connection to the territory and given the creation of this land border, which arguably is a colonial construct, that by virtue of those two elements, in addition to others, that there would be a sufficient connection to the land allowing Mr. Desautel to exercise his rights, despite not being physically in Canada. So I wonder how you reconcile that perspective with the submission you're making today.
Respectfully, Justice, it is the submission of the appellant that in order to ensure Aboriginal rights of Aboriginal groups located inside of Canada, strict guidelines must be placed in order to understand where the scope of the protection of Section 35(1) is, and to recognize the prior occupation and promote reconciliation with the Aboriginal peoples of Canada. As we see, Section 35(1) of the Constitution elevated to constitutional status the common law rights of the Aboriginal peoples of Canada that were existing in 1982. Aboriginal groups located outside of Canada's borders simply do not fit in with this understanding.
Counsel, I have a problem with that, because in recognizing that we have a responsibility and a duty towards reconciliation, does it not go then hand in hand the requirement to recognize that many Aboriginal groups are nomadic in nature and that their territory extends beyond just the currently, as my brother Justice mentioned, the currently drawn colonial borders of the country of Canada and into the United States?
Yes, Justice. And a purposive analysis of Section 35(1) and the wording Aboriginal peoples of Canada establishes that it protects only Aboriginal peoples located within Canada, as this approach is consistent with the fact that constitutional provisions conferring rights must be placed in their proper contexts in order to avoid overshooting their actual purposes. As noted in the case of R. N. Blaze, this court is not free to invent new obligations foreign to the original purpose of the provision at issue. The analysis must be anchored in the context of the provision, and Section 35(1) accords constitutional protection only to the rights of the Aboriginal peoples of Canada. Which brings us to the linguistic context of Section 35(1), in which we analyze the linguistic matter. It is a well-established presumption of statutory and constitutional interpretation that each and every word of a text must be given meaning. As such, it becomes imperative to address that the inclusion of the words of Canada cannot be seen as trivial. The word was chosen as a qualifier rather than simply using the words Aboriginal peoples. Legislature uses language carefully and consistently, and this is no different in the case at bar, as well as the Constitution Act, where geographical qualifiers are used elsewhere, including in examples such as official languages of Canada and government of Canada. In the case of Frank and the Queen.
I'll ask you then about wording and superfluous wording. Section 35 sub 2 says that in this act, Aboriginal peoples of Canada includes the Indian, Inuit, and Métis people. That's not an exhaustive definition. And so does that mean that this provision in 1982, when it was drafted, always had the possibility of being interpreted in a more expansive fashion?
Justice, while I understand where this is coming from, it is the position of the appellant that when solely looking at the context of Section 35(1) and the phrasing used and giving meaning to each and every statement used in the section, it must be analyzed as a geographical qualifier.
Right, but when we interpret the Constitution in Canada, we don't just look at the words of the text, right? We're not in the United States. We're not originalists, right? We're not textualists. It's not how we interpret our Constitution. The living tree doctrine is alive and well when we interpret the Charter and any other constitutional protections. So would that not then detract from the argument that you're making and actually support a logical inference that we in fact should be expanding protection to include those who were affected by the colonization of the land known as Canada?
And also to piggyback off of my brother Justice's question, I'd like to point out the fact that since you're relying on a linguistic interpretation of the words of Canada, it would be incumbent upon us to include reviewing the definition, or excuse me, the wording in French as well, which is one of the two official languages of our country. And in French, du Canada means from Canada, not of Canada. So taking our two questions in consideration, how would you address these concerns?
Justices, in the submission of the appellant, we look to not just the linguistic context, but also the philosophical and historic context placed of Section 35(1). In the philosophical context, it is important to acknowledge the grand purpose of Section 35 as described in Beckman and Little Salmon Carmack's First Nation, which is the reconciliation of Aboriginal and non-Aboriginal Canadians in a mutually respectful long-term relationship. Section 35 protects Aboriginal peoples as full participants with non-Aboriginal peoples in a shared Canadian sovereignty. The protections therefore do not and cannot apply to Aboriginal groups in other countries. It is the submission of the appellant that upon interpreting Section 35 through relevant linguistic, philosophic, and historic context that we can reach this definition, which brings us to the final context being that of the historical. The limited historical sources that could provide guidance as to the meaning of the expression Aboriginal peoples of Canada show an intention to limit the constitutional protection of Aboriginal rights to only those located within Canada. This court cannot impose an intention to broaden the constitutional protections under Section 35(1) beyond what was already contemplated.
Could I break in for just a moment? Right across the country, there are peoples, nations who made treaties with the Crown. And after those treaties, the Canada-US border was drawn through those peoples and those territories. For example, in Akwesasne, the village of Ganadago, the border runs right through the village. So what you're saying is the people living north of a line have Canadian legal protection, and their family members 3 meters away have none because the border was drawn after the treaty. So Canada is effectively repudiating its treaty relationship with half the people there. Is that the consequence of what you're doing?
Justice, although Section 35(1) recognizes and affirms the existing Aboriginal treaty rights of the Aboriginal peoples of Canada, defining those rights is a task that has fallen largely to the courts. The honor of the Crown requires a generous and purposive interpretation of the provision in furtherance of the objective of reconciliation, and it is the position of the appellant today that as such, Section 35(1) only applies to those in Canada. And while the appellant would once again like to acknowledge the delicacy of the relationship between the government of Canada and Aboriginal peoples of Canada, we must understand that through a purposive analysis of relevant contexts, Mr. Desautel does not fall within the scope of Section 35(1). I see that I have around 15 seconds remaining. Can I request an additional 15 to wrap up my conclusion?
There is no additional time. Please just wrap up.
Thank you. My co-counsel will now address the further submissions that even if Section 35(1) were to extend across the border, Mr. Desautel cannot prove an exercise right. Thank you.
Okay, I will begin my submissions now. Good morning, members of the court. My name is Sydney Gummerson, and I will be concluding the submissions on behalf of the appellant, Her Majesty the Queen. The appellant submits that even if Section 35(1) were to extend across the border, Mr. Desautel cannot prove that he was exercising an Aboriginal right to hunt in traditional territory, as the Lakes tribe lacks continuity with the pre-contact sittings group's practices. I will also submit that there are many potential consequences that may arise if the court were to rule in favor of the respondent. Even if this court should conclude that a member of an Aboriginal collective located outside of Canada can claim the constitutional protections of Section 35(1), Mr. Desautel cannot establish the continuity element of his Aboriginal right claim to hunt for ceremonial or traditional purposes in traditional territory. Therefore, the appellant submits that the claim should fail based on inability to satisfy the Van der Peet test for establishing an Aboriginal right. The respondent may argue that the test for proving an Aboriginal right does not require an unbroken chain of events. However, while temporal gaps do not necessarily preclude the establishment of an Aboriginal right, failing to tender sufficient evidence that at least a connection to the historical practice was maintained during such gaps may be fatal. Continuity must be interpreted flexibly. Such flexibility, however, has its limits. Mr. Desautel, as a member of the Lakes tribe, cannot establish that he was exercising a modern-day Aboriginal right to hunt in the Sinnings traditional territory in British Columbia. While the appellant recognizes that the Lakes tribes are a modern successor to the Sinnings tribe, originally located in Canada at the time of European contact, the modern group's claims lacks continuity with the pre-contact group's specific practices, which is necessary to establish in order to prove an Aboriginal right. Section 35(1) protects only those present-day practices that have a reasonable degree of continuity with the practices that existed prior to contact.
Right, but isn't the reason, Counsel, that there, in your view, there may be no continuity or there is insufficient evidence showing continuity? Isn't the reason for that, isn't that the Crown's fault? Ultimately, the fact that this international border was drawn, which arguably is a foreign concept to the Aboriginal peoples. The fact that an international border exists right now, that it was created roughly 150 plus years ago, right? Ultimately, it wasn't a voluntary decision by the Aboriginal peoples to move south of the American border. So how does that factor into our assessment?
Respectfully, Justice, Aboriginal rights claims require that there is proper and sufficient evidence that be gathered and adduced to meet the legal requirements for such rights under the Vanderpeet test. The fact that there was a large period of dormancy where no hunting took place in the traditional Sinings territory is what causes Mr. Desautel's claim to fail.
Right, but wouldn't that be ignoring the fact that many would argue that the reason that Mr. Desautel is not able to adduce more evidence is because of the international border that was drawn, because of the actions of the Crown?
Justice, the question becomes, though, why wait so long to travel to British Columbia to continue the traditional practice? The Sinings tribe, the established predecessors of the Lakes tribe, exercised a robust seasonal round in all of their traditional territory, including those lands in British Columbia. Well, there doesn't need to be a continued presence in the land. The fact that there was no continuation of the seasonal practice for a period of from about 1930 to 2010 is a long dormant period to consider, and it's an unaccounted for absence within the state of British Columbia.
But what would have been adequate then? Would every 10 years be sufficient, or would it have to be an annual visit?
Sorry, do you mind rephrasing your question, Justice?
Well, we're talking about continuity here, and we're talking about showing that a right was continuously exercised, or a connection to the land was exercised over the last 80 or so years. And in your submission, that is not the case. So I'm wondering what level of connection would have been sufficient? Would yearly travel to the land be sufficient, or would it have to be every 5 years or 6 years or 20 years? At what point do we draw the line and say, okay, that's enough travel? We said he's established sufficient connection to the land. He's gone there enough. When do we say, where does that fall?
The respondent is of the view that the trial judge made a legal error in concluding that this continuity had not been broken by the length of time that Mr. Desautel had in order to establish an Aboriginal right to hunt in British Columbia. And while the respondent acknowledges that the trial judge's findings of fact are owed deference because of the weighting of evidence in an Aboriginal rights claim, as it's generally the domain of the trial judge who is best situated to assess the evidence as it is presented, the facts as she found them do not meet the continuity requirement necessary to establish an Aboriginal right. The issue here is that there is no direct evidence between 1930 and 1982 and between 1982 and 2010 that the Lakes tribe engaged in anything that could be considered a modern day practice of Sinings hunting in this territory. The only
by that you're saying that this isn't a case about rights, this is just a case about this individual hasn't proved enough of the facts. You're conceding the right? If somebody was hunting across the border, even illegally, with sufficient continuity, you'd say that's an Aboriginal people of Canada?
If this court were to conclude that Mr. Desautel would be considered an Aboriginal peoples of Canada under Section 35(1), the next step to be considered would be the Vanderpeet test, and it is the position of the respondent that even if this is concluded, the continuity element is what makes the claim fail under this Vanderpeet test. The only evidence that the Lakes tribe maintained a connection to the claimed right was the fact that the land was not forgotten in the minds of the Lakes Tribe members and that the Lakes Tribe engaged in similar hunting practices in Washington state. While the appellant acknowledges the unique quality of physical and ancestral land to the Aboriginal peoples, the test for Vanderpeet simply requires more evidence. Continuity cannot be established simply because there is evidence that the land was not forgotten in the minds of the Lakes Tribe members. This may reach into further consequences from that. This is not and cannot be the standard. With the fact that the Lakes Tribe engaged in some...
Wouldn't this place a higher burden on those communities that have been displaced, even if it was by force or the resurrection of an international border?
Justices, the appellant acknowledges the unique circumstances of Aboriginal peoples who may have been forced out of the borders created by colonization. However, the fact is that sufficient evidence is required in order to establish an Aboriginal right within Canada's borders. As in the case of Mr. Desautel, the idea that the land was not forgotten cannot be standard within the courts. With the fact that the Lakes Tribe engaged in hunting practice as well in Washington state considered, this evidence remains inconclusive. There's a boundary that must not be crossed between a sensitive application and a mistake of the rules of evidence. The Lakes Tribe had an absence from the province for a period of almost 30 years from 1982, when existing Aboriginal rights were elevated to constitutional status by the Constitution Act, to 2010, when Mr. Desautel traveled to British Columbia for the purpose of shooting a cow elk. Given this lengthy and unaccounted for absence from British Columbia between 1930 and 2010, continuity is not made out between the modern day action and the pre-contact practice. The fact is, there is not sufficient evidence within this period of time that the historical practice of hunting on this specific land was continued or integral to the culture. Therefore, even if the Lakes Tribe were found to be part of the Aboriginal peoples of Canada, the lack of continuity would be fatal to Mr. Desautel's claim. Additionally, based on the potential of ruling in favor of Mr. Desautel on either account, the appellant submits that there would be consequences in the legal system. If the appeal is dismissed due to Mr. Desautel being considered an Aboriginal people of Canada and being protected by the Constitution Act under Section 35(1), this could potentially be unfair to Section 35(1) rights holders residing within Canada, whom we are currently working as a Canadian institution to build a better relationship with.
How? Can you just clarify that? How would it be unfair to those who already enjoy the benefit of Section 35(1) protection?
Yes, Justice, the respondent may suggest that Aboriginal communities outside of Canada can assert and hold these Section 35(1) rights, but it wouldn't mean that their rights are the same as those local communities within Canada. However, if an Aboriginal group outside of Canada is entitled to exercise Section 35(1) rights in Canada, then it must have equal protection under the Constitution and be able to access and exercise a full panoply of rights in the same fashion as Aboriginal rights holders within Canada. Nothing less than this would uphold the honor of the Crown and further Canada's ongoing process of reconciliation with its First Peoples. If constitutional rights are given to members outside of Canada, this can be in direct conflict with providing protection and support to those within Canada. This can lead to problems with the duty to consult, as well as constitutional practices. Aboriginal peoples of Canada are invited to be representatives of these groups at constitutional conferences. This is contrary to the organizing constitutional principle of democracy and inconsistent with the purpose of patriation to allow Aboriginal groups outside of Canada to participate in Canadian democracy. It can also be anticipated that in some cases, accommodating the interests of Section 35(1) can result in problems under the duty to consult, for rights holders outside of Canada could potentially run counter to accommodating the interests of those within Canada. This does not fit under the purpose of Section 35(1) of reconciliation with the Aboriginal peoples of Canada, who are considered full participants in Canadian democracy. Due to the lack of continuity in the claim and the consequences that will arise from ruling in favor of the respondent, the appellant submits that the appeal should be allowed on the basis that an Aboriginal right has not been proven. A verdict of guilty should be entered on both counts of hunting without a license and hunting big game while not being a resident of Canada under Section 11(1) and 47A of the Wildlife Act, respectively, and the matter should be remitted to the trial court for sentencing. Barring any further questions, the appellant therefore concludes their submissions.
Thank you, counsel. If the judges are ready, we can move to hearing the respondent submissions. And it looks like we may be, so the respondents may proceed.
Right, Justice. May I please the court? Good afternoon, Chief Justice and Justices of the Honorable Supreme Court of Lions Cup. My name is Firza Shabazz. I, along my co-counsel, Lila Belzi, represent the respondent, Richard Lee Desautel. The appellant submitted that of Canada means within the boundaries of Canada. However, an individual who's never stepped foot into Canada can still be a citizen of Canada. On the other hand, the Lakes tribe, who have an ancestral connection to the land, who have been here for thousands of years, are not considered an Aboriginal peoples of Canada, conflicts with the purposes of Section 35. That which is to recognize that there was a prior occupation of the land and to reconcile their modern day existence. At issue is whether the respondent's claimed Aboriginal right to hunt for food, social and ceremonial purposes exempts him from the provisions under which he was charged. The respondents will be presenting two issues today. I will be addressing the first issue and my co-counsel will be addressing the second issue. The first issue will deal with whether the Lakes tribe is an Aboriginal peoples of Canada, and the second issue will deal with the continuity element and if it's been met by the Lakes tribe in accordance with the Van der Peet test. I will be making two submissions. The respondent respectfully requests that this court dismiss the appeal and answer the constitutional question in the affirmative. I will be making two submissions today. First, I will present the importance of Aboriginal perspective. Second, the importance of belonging in relation to the ancestral land. Beginning with my first submission, I submit that the purpose of Section 35 is to not only recognize and reaffirm the rights, but to reconcile. The proposed interpretation of Section 35 encompasses the modern day successors of the Senex tribe, that which is Mr. Desautel. It's about recognizing that there was an occupation of the land prior to European contact that had their own way of living, their autonomous societies, and their own legal traditions. In addition, to reconcile the modern day existence while maintaining Crown sovereignty over them. As was demonstrated in the Queen and Sparrow, the Supreme Court of Canada in 1990 stated that the interpretation of Section 35 is to be taken in a liberal, generous manner that not only encompasses the Crown's perspective, but the perspective of Aboriginal groups. Specifically holding the Crown at a higher regard to take in the interest of Aboriginal groups. In Sparrow, the test for Section 35 was created to see whether there was an infringement of the rights. And it states that existing Aboriginal rights allows for flexibility with rights over time. It allows for the rights to evolve, as well as recognized and affirmed, is to highlight the appreciation of the history, as well as developing the relationship between the Crown and Aboriginals.
Counsel, I have a question for you, and the appellants they based their submission on this largely, and it's around interpreting Section 35. Nowhere in Section 35 do we see that there was any thought given to providing constitutional protection to Aboriginal peoples physically located outside of Canada. But not only that, but we even looking at the history of Section 35 and when it was drafted, nowhere in Hansard debates or any reports at constitutional conferences is there mention that of any indication that the framers of the Constitution gave thought to actually including constitutional protection for these groups. So I wonder, how are we to base, how can we actually base our decision today when there is in fact apparently no evidence that would support the position that you're advocating for?
Thank you, Justice. The authority for Section 35, if we look to Mitchell and Minister of National Revenue. The purpose of Section 35 is laid out, and it states that it recognizes that prior to European contact, there were Aboriginal groups living within what is now Canada. They were living on the land that have an ancestral connection, as well as the fact that they, sorry, moment's indulgence. Thank you. So in Mitchell and Minister of National Revenue, in paragraph 29, it explains that there were Aboriginal groups on the land prior to European contact that had autonomous societies and their own way of governing, as well as in Mitchell and Manitoba Métis Federation and Canada. It's in paragraph 30, it states that the special relationship between the Crown and Indigenous groups. So the respondent is basing their interpretation, their propulsive interpretation of Section 35 on the evidence that was provided in the two cases, as well as both perspective and ideas are required to further reconciliation of both the Crown and Aboriginal groups. In addition, it was demonstrated by Professor John Burroughs in Earthbound Indigenous Resurgence that even though Aboriginal groups have been removed from the physical ancestral land, they're still connected in their hearts and in their minds to the land. Secondly, I submit that Indigenous groups, like the Lakes Tribe's center focus, are their ancestral connection to the land. In this situation, Mr. Desautel has an ancestral connection to the land as a modern-day successor of the Sinextra. In accordance with the Royal Commission on Aboriginal Peoples, it was highlighted through the Aboriginal perspective that the identity of Aboriginals lies in the heart of their existence, and it's essential to groups living in the city or urban areas, whether it be in America or it be in Canada. They're still connected to that land. The culture.
I have a policy question for you. I guess it's about the implications of this decision as a matter of public policy for future claimants. And my question is, if we were to grant individuals like Mr. Desautel protection under Section 35, allowing him or giving him an Aboriginal right to hunt on land in Canada, how would that be compatible with the fact that Mr. Desautel, by virtue of being a US citizen, doesn't have a right to enter Canada under Section 6, namely mobility rights? Is that not incompatible? The fact that he is not able to be in Canada as of right under the Charter, but we would be giving him an Aboriginal right under Section 35 to hunt? How is he supposed to exercise that right or ensure that right will be exercised in the future?
Thank you, Justice. Mr. Desautel entered the country legally, so Section 6 is not a problem in this situation. And we're not saying we're allowing people or groups to illegally enter. That's completely a different thing, and we're not addressing.
No, I agree with you that he entered legally in the situation. But what I'm saying is, if we recognize a right for individuals like Mr. Desautel to come to Canada to hunt, those individuals don't actually have a right under Section 6 to be in Canada, under Section 6 of the Charter. So is that not incompatible? How can we guarantee that they would be able to exercise their Section 35 rights if they're unable to enter Canada as of right under Section 6?
Maybe I can phrase that a little bit differently. If you've got a right to hunt somewhere, don't you necessarily have a right to be there?
Right.
Right. So Mr. Desautel does have a right to be there. He has an ancestral connection to the land, as is demonstrated in Section 35, that prior to European occupation, these individuals, these Indigenous groups had a connection to the land and therefore are allowed to practice on the land. So although the Lakes Tribe is in America, their ancestral connection to the land is always in their roots of their identity and in their minds. And if we look to the trial judge's finding in paragraph 125, when Mr. Desautel was asked what it meant for him to be on the same land as his ancestors and what it meant for him to hunt there, he stated, "When I come up here, I'm walking with the ancestors and God. I just think about the times that they were going up the mountain like this here. And Michael Marchand, another member of the Colville Lake tribe, states, and we try, even though we can't go back in history and exactly duplicate those things today.
Counsel, you're short on time, so I'm gonna try to redirect this here, just because you mentioned Mitchell and you brought up the Royal Commission. Mitchell itself at paragraph 135 makes reference to the Royal Commission and talks about how that Aboriginal peoples are indeed part of the Canadian sovereignty. And that's the purpose of section 35. What you're suggesting here is that Canadian sovereignty then also includes non-Canadians who will have the ability to operate within Canada without a passport, without a visa, without any controls or checks whatsoever. And that seems to undermine that notion that's there in Mitchell 135. If you can address that, please.
Thank you, Chief Justice. I'm not saying that he's allowed to come here illegally or without a passport. Mr. Desautel had all of those things. He came here legally. That's not the issue today in this case. And we're not saying to undermine Canadian sovereignty, but it's supposed to be hand in hand. The purpose is reconciliation. And in order to reconcile and in order to restore those relationships, you need both the perspective of Aboriginal groups and the Crown. So in conclusion, the issue at hand is modern day successors like Mr. Desautel have not given up their land or their cultural identity. Their roots are planted in Canadian soil, and to weed out one would mean the downfall of reconciliation. Respective Chief Justice and Justices, it's in the hand of this Honorable Supreme Court, with the utmost regard to the Aboriginal perspective, plant the seeds for further reconciliation. Subject to any questions, those are the respondent submissions.
How come you said Aboriginal peoples? That is, why the plural for one individual? I'm just playing grammar here, but it's always bugged me.
I apologize, it may have slipped. I do mean Aboriginal people, Indigenous people.
No, I mean, a number of people, including Counsel for Rick Desautel, have said, is Rick Desautel an Aboriginal peoples of Canada? When my gut says, no. He is a citizen of an Aboriginal people. So are we talking about the concept of a people? Or are we just talking about words in the Canadian Constitution?
I'm strictly referring to words in the Canadian Constitution. I apologize if there was.
No apology. I'm just curious. Or mischievous, I can't tell which.
Thank you, Counsel, and Your Honors, that is time.
Thank you.
May it please the court, I will proceed. Good afternoon, Justices of the Honorable Supreme Court of Lions Cup and Chief Justice. My name is Lila Belsey. In support of the respondent's position that the Supreme Court of Canada correctly held that the respondent satisfied the continuity element required for Aboriginal rights set out in the Queen and Vanderpeet, decided at the Supreme Court in 1996, I will be making two submissions today. My first submission is in regards to any potential issue that arises from brief lapses in occupation and land use by the Sinixt people in British Columbia. Any ambiguity arising from these lapses, the court must find in favor of Mr. Desautel. Second, the lapse in question is not a significant enough portion of time to negate the millennia of time that the Sinixt maintained their practices before and after European contact, and to dispute that fact would ignore the Aboriginal perspective on the matter.
So then what would be enough time? At what point do we draw the line, Counsel, and say enough time has lapsed?
Respectfully, Justice, in the submission that we're proposing here, we submit that it's necessary to look at these cases on a case-by-case basis, dependent on the evidence that is submitted by the Aboriginal person in question. So I'm not here to tell you what a particular year would be or a particular quantity would be sufficient. I'm here to tell you that in this particular case, there is sufficient evidence to maintain continuity. To return to my first submission, the issues of ambiguity that arise in cases such as this, in line with the provisions of Vanderpeet, must be ruled in favor of the Indigenous person in question. Now, the main issue that came up in the dissent at the Supreme Court, as posed by Justice Cote, was that flexibility when you interpret continuity must have some limits, and that the ambiguity in this case that arises from these lapses could prove fatal to the case, in that it creates an ambiguous situation. I would like to respectfully submit that this is not accurate. As is laid out in Vanderpeet, when there is a statement that there is no need for an unbroken chain of continuity. Now, if we go back to the trial judge's findings, we find that the Sinixt people had a continuous occupation of their traditional territory of West Kootenay under the name of the Arrow Lakes Band, which is a sister group to the Lakes Colville tribe, to which Mr. Desautel belongs. Collectively, as the Sinixt, these people followed a migratory hunting practice that spanned from the northern half of their territory in what is now British Columbia to the southern half, which is now Washington State. The establishment of an international border at Confederation through this traditional territory fettered these people's ability to practice this migrational hunting. Mr. Desautel, in traveling to the territory of his ancestors in the northern portion of this traditional territory, is indeed maintaining a historic practice that was practiced by his peoples for thousands of years. The amount of time between—
But Counsel, I guess you may just have just been getting to this. Why wait 80 years? If continuity is such an important piece of this test, which it is, as we all know, wouldn't we expect that the right would have been exercised earlier?
That is a good point, Justice, and I have some information to point out to you in that regard. So as I had previously mentioned, there is this establishment of an international border across Indigenous land. This is a colonial border which no Indigenous group was consulted about and did not consent to. We're looking at the Oregon Boundary Treaty here in 1946. This crossed through this traditional territory. There was also an act made. It was the Game Act in 1896, which at this point in time, the Wildlife Act is a continuation of this original act, which outlawed hunting by Indigenous peoples in British Columbia. In addition to that, those legal factors, there were also increasing instances of gun violence and death of Indigenous peoples imposed by conflicts with European settlers. So all of these factors contribute to the reasoning why there's not necessarily a huge rush for these people to go back into their traditional territory. They're facing legal issues, colonial legal issues, and they're facing violence on the behalf of European settlers. And if we ignore this, if we ignore all of these factors and we just say that in this instance, these people didn't continue to practice migrational hunting, they only practiced in the southern half of their traditional territory, we are ignoring the perspective of the Aboriginal people in question here when we say that all of these legal issues and these violent issues don't matter and they should have continued to practice like this anyway. And we are ignoring the fact that we are imposing a colonial perspective on them when we say that you should have continued this practice going north and hunting in this traditional manner. Now, my friend stated that it is a long dormancy period. And I would like to argue that it is not a long dormancy period when you consider the thousands of years that these people practiced on this land, as was found by the trial judge. There is not, this 80 years of dormancy is not significant when you measure it against this thousands of years of pre-colonial practice. And it's not significant in terms of the over 100 years that they continue to practice post-colonial. Pardon me, if I could have a moment's indulgence to just gather my thoughts here. Thank you. And it's not significant in regards to the 120 years post-European contact that they continued this practice. Now, the the appellant submits that there is this instance of the creation of this Oregon Boundary Treaty, and how that this didn't necessarily prevent people from going over the border and hunting, even though this was now made illegal. So I would submit that in order to consider the Aboriginal perspective, as is necessary, as my co-counsel has outlined, when you look at a purposive interpretation of Section 35 of the Constitution, we have to look at these instances of cross-boundary traveling, even though it was illegal, not necessarily as evidence that these people were not stopped by the international border, but that their commitment to continuous practicing is established regardless of these boundaries that are imposed on them.
Counsel, how do you propose that the Crown would discharge its duty to consult moving forward if we were to find in favor of Mr. Desautel in this case, and specifically the duty to consult when future Aboriginal groups located on the other side of the border are involved?
Justice, may I clarify what you're asking me?
What I'm asking you is, given that the duty to consult has typically only been engaged within Canadian borders, I wonder, how would the Crown be able to know when to consult or who to consult with if we're talking about groups that are located on the other side of the border?
So I believe the question is, thank you, Justice, for that question. If we proceed with this matter and we find in favor of Mr. Desautel, there is a duty to consult all of these potential groups who did have history in Canada but do not occupy Canada any longer. So in this instance, the policy that the Crown should mandate is to look at the historical patterns of Indigenous occupation of the territories that potentially go across international borders. Right,
and in this case, as far as the Crown or the government of Canada was concerned, the ancestor group was extinct, so to speak. So how would they know?
Well, I would submit that the ancestor group was not extinct. The government declared as such, the Crown declared as such, and reclaimed the reservation land that was attributed to the Arrow Lakes Band when the last member died in 1956. However, there were still many individuals living under the name the Lakes Colville tribe continuously existing in Washington. So in this rather questionable government declaration of an Indigenous group becoming extinct, I would suggest that you can't necessarily rely on that, and you would have to look at the history of the peoples in question and whether there are sister groups like the Lakes Colville tribe. These peoples were not extinct. They continuously lived in the southern half of their traditional territory, and I would submit that this was an error on behalf of the government. So that there would be a necessary mandate that we can't arbitrarily decide that peoples are extinct because they no longer exist within the boundaries of Canada when they exist quite nearby continuously after that.
The test here, though, Counsel, still requires a distinctive society, right? And the Colville is actually a collective of different peoples where there is intermingling. And some of the Siniksta actually joined a Canadian group of the Kootenaksa. So, you know, I think they were assimilated, if you will, by many other peoples. And so my concern here is that paragraph 28 of Vanderpeet very clearly says that the common law Aboriginal rights could have been extinguished at any time. And isn't that, I think that's an extension to the previous question, isn't that what happened, is that there was an extinguishing of those rights, and now there's an attempt post Section 35's enactment in 1982 to create them again?
To your question, Chief Justice, I would submit that yes, maybe there was an extinguishment of a common law right. However, there is no judicial history of the extinguishment of a constitutional right. There's no precedent for that. This court has never decided as such that a constitutional right can be abandoned by disuse. So I would look at the fact that we're arguing constitutional right and not necessarily common law. If I could briefly conclude, those are the respondent submissions. We respectfully request that the court dismiss this appeal and answer the constitutional question in the affirmative. Subject to any questions, that is my submission. Thank you, justices.
Thank you, counsel, and thank you to all of the representatives from both sides for your submissions here today. The judges will now retire for deliberation.
Thank you, justices.
I would kindly ask the council to please exit the breakout room, but take care not to leave the meeting by mistake. And I would also ask Chief Justice Omar Haredai to please text Jen with the results of the round. And for their convenience, I will post the team numbers and names for the judges to consult.
I think we accidentally lost one of our.
Yeah, we lost a judge.
Carolyn.
Carolyn Wong, I see. I'll try to pull her back in. Thank you for catching that.
While you're doing that, I'm going to grab my phone so I can send that text.
Sure thing.
We'll just wait for Omar to come back.
So I guess we're still waiting for the other judge, right? We want to make sure that we're getting all the perspectives here.
That's right. I think unfortunately she may have fallen off the call. Well, I'll stop the recording for now.